If you need protection from someone in Broward County, Florida, you can file what's called an injunction. Some people call it a restraining order. But how do you actually file one? And when you do file it, what happens next? Let's walk through this step by step so you can learn how to do this if it's something you need. I'm Dave McGilligan. I'm a lawyer here in Broward County. Our firm helps people with injunctions every week, whether they're filing them or defending against them. Today, I'll go over the basics of filing in Florida so you know exactly what to expect. First of all, you want to know what is an injunction. An injunction is a court order, and in this case meant to protect you from violence, threats, or harassment. Florida has several types: domestic violence, dating violence, stalking, sexual violence, and repeat violence. The most common is domestic violence, but the filing process is similar across the board. First of all, where and how do you file? In Broward, you can file at the courthouse in downtown Fort Lauderdale. You'll go to the domestic violence intake unit. You'll fill out a sworn written statement. That's your petition, and explain what happened and why you need protection from this person and what type of injunction you're asking for. There are no filing fees, and if you're in immediate danger, you can ask the judge for a temporary injunction that same day. Now, you're probably wondering, what do I put in this petition? This is critical, and at this stage, it's the most important part. The judge makes their first decision based only on what's in your written petition, and you need to be specific. Don't just write, "He harassed me." Instead, write, "On September 12th, he came to my house. He yelled at me. He pushed me." Dates, times, places, details. The more information and detail that you can give the judge, the better they can understand why you would need protection and why they grant it. Now, once you file this petition, a judge usually reviews it that same day. If the judge thinks you need immediate protection, they can issue a temporary injunction. Sometimes people call this an ex parte order. The temporary order usually lasts up to 15 days until the court can set a full hearing. Law enforcement serves the other person with your petition and the temporary order. Now, at some point, there will be a final hearing. This is the step in front of the judge. This is where you tell your side of the story and the respondent, the other party, can tell their side of the story. The judge will hear testimony. They will look at evidence and decide whether to put a permanent injunction in place. The hearing is basically a mini trial. I mean, there's not jurors and no one's going to jail in the hearing, but it's an important part of the process. Now, why does legal help matter? Even though the filing is free and you can do it yourself, a lot of people find out the hard way at the final hearing. It's not that simple. If your petition doesn't have enough detail, or if you're not ready for a cross-examination or to cross-examine someone, you can lose. And once you lose, it's hard to get protection again on the same facts. And that's why it's smart to talk with a lawyer before your hearing. Better yet, it's probably better to talk to a lawyer before you file a petition. So to recap, you can start by filing a petition at the courthouse. Be as specific as possible in your written statement. A judge can give you temporary protection right away. Then you'll have a final hearing where both sides are entitled to present evidence. Now, if you're in this situation where you need protection or you've been served with an injunction, call our office. We handle these cases every week. We can guide you through the process. This is Dave McGilligan from Magilligan Law. If you like what you've heard today, subscribe and check out some of our other videos. Thanks.